In this penultimate lecture in our Big Picture series, I want to turn to the UK's membership of the European Union and to think about what its implications are or were for the British Constitution and our understanding of it. In particular, I want to ask, what does the period of membership reveal, or what did it reveal, about the nature of the British Constitution? And what are the longer-term implications that might continue to be relevant now that the UK has left the EU? Now, at the end of the previous lecture, we finished with what I described as a potential paradox as the conclusion to our consideration of the territorial constitution and its potential implications for the question that we're looking at throughout this series of lectures on the extent to which the Constitution is flexible and malleable on the one hand, and the extent to which it has fixed aspect to it on the other. In relation to the territorial constitution, I suggested that a paradox potentially arose because on the one hand, while the sovereignty of Parliament is the ultimate guarantor of the Constitution's flexibility, because it makes anything legally accomplishable simply through the enactment of regular legislation, it may also introduce a problematic degree of rigidity into the Constitution if, for example, it prevents the way in which the Constitution works and the way in which the territorial constitution works in particular, if it prevents that from being developed in ways that might be necessary given changes to the wider political environment. And we saw an example of that in the arguments put forward by the Welsh government as to why it felt that the traditional understanding of sovereignty may no longer be fit for purpose in a very different UK that consists of four nations which are to an extent autonomous. So I want to pick up in relation to the EU now by beginning with another potential paradox. The paradox that I think is revealed through our examination of this topic is that while, as we'll see, parliamentary sovereignty has been shown through the experience of EU membership to be more malleable or less fixed than perhaps it was previously thought to be, the very revelation of that flexibility in terms of the sovereignty of Parliament may have served to reveal other enduring constitutional values that in other respects make the Constitution more durable, that introduce greater sort of fixed points into it, and that may in turn reduce the capacity of parliamentary sovereignty for exploiting the supposed flexibility of the Constitution. In other words, I think that EU membership has shown sovereignty to be more flexible than we supposed before, but it has shown other aspects of the Constitution to be potentially more fixed. And that obviously has implications in and of itself, and it also has implications which you may want to go back and think about again once you finish looking at this video for the issues that we considered in relation to the territorial constitution. Let me start then with the basic tension, or at least apparent tension, that seems to arise in this area. And that's the tension between the principle of parliamentary sovereignty, which is a principle of the domestic constitution, and the EU law principle of the primacy of EU law. As we know, parliamentary sovereignty, understood in its traditional sense, holds that Parliament can make or unmake any law, and that no person or body of persons can override or set aside laws enacted by the UK Parliament. A difficulty appears to arise, or appeared to arise, for as long as the UK was a member of the EU, when the sovereignty of Parliament was viewed against the picture of the primacy of EU law. According to that doctrine, EU law cannot be overridden by domestic law, and domestic courts are required to prioritise EU law in the event of domestic and European law conflicting with each other. And this clearly presented the UK courts and UK constitutional theorists with a difficulty. How, if at all, to square this circle? Now, one of the defining characteristics, I would say, of the British Constitution and of the way in which it is thought about and in which it is operated is that it is ultimately a highly pragmatic constitution. And we can see that pragmatism playing out in the Factortame case, in which the House of Lords directly confronted for the first time this difficulty about the relationship between the sovereignty of Parliament and the primacy of EU law. The House of Lords came to a very sort of practical and pragmatic conclusion in holding that a piece of domestic legislation, the Merchant Shipping Act 1988, which was incompatible with directly effective EU law, should be disapplied to the extent of the incompatibility. So the practical demands of the primacy of EU law were satisfied. But in coming to that very significant conclusion that may appear to have called into question the domestic principle of parliamentary sovereignty, the House of Lords strikingly had almost nothing to say on that subject. Lord Bridge was really the only judge who considered this issue at all, or in any meaningful sense, in his speech. And he confined himself largely to noting that any limitations on sovereignty entailed by EU membership had been known about prior to the UK joining, and that implied that any limitations had been voluntarily accepted. But there was no real attempt to explain how any of this might operate at the level of constitutional theory, or what its deeper implications might be for the concept of parliamentary sovereignty. Now, there are a number of different ways in which we could think about this, and I've just outlined on this slide a couple of possible approaches. And if you like, these represent the two extremes, the two sort of ends of a spectrum, and we'll see as we go on in this lecture that there are other intermediate possibilities that in the end found greater favour. So one possibility would be to take the sovereignty of Parliament as an absolutely rigid and fixed aspect of the UK Constitution, such that it would render sovereignty an absolute obstacle to the accommodation of the primacy of EU law. This would certainly have the merit of treating the sovereignty of Parliament in what might be regarded as an orthodox or traditional way, if indeed that should be regarded as a benefit. But it would also be highly inconsistent with what I've just described, namely that very pragmatic approach that we tend to find in UK constitutional law. And it would also have been irreconcilable with the outcome of the Factortame case. Often, when we look at cases in this area, we see an implicit recognition on the part of the courts that certain realities have to be accommodated. And one of those realities, for as long as the UK was a member of the EU, was that there had to be some way, to some extent at least, of accommodating the primacy of EU law, treating the sovereignty of Parliament as an absolute fixture that was incapable of yielding to any extent so as to accommodate EU primacy would not have been compatible with that, and wouldn't have been compatible with the pragmatism that I've described. So we shouldn't be surprised that theoretical rigidity didn't find favour with the UK courts, either in Factortame or in any of the cases that came after. If we go to the other end of the spectrum, we might regard sovereignty not as a fixture, but as something that could be readily sort of steamrollered out of the way. And here we might regard EU law as an overriding force, something which overwhelmed or even extinguished the doctrine of parliamentary sovereignty, at least for the duration of Britain's membership of the European Union. And I think that it's arguable that we find at least elements of this kind of view in Sir William Wade's account of how EU law came to occupy the position it did in the UK during its period of membership. Sir William Wade argued that the way in which EU law had been received amounted to nothing short of a constitutional revolution, and that in effect the sovereignty of Parliament, through judicial willingness to recognise the primacy of EU law, that parliamentary sovereignty had therefore really been swept aside by the developments that the court chose to acknowledge. That view certainly accords with the outcome of factor time in the sense that the primacy of EU law is accommodated, but it doesn't really accord with the way in which courts went on in subsequent cases to think about these issues. Indeed, to the extent that Wade's approach presupposed a shift in the very fundamentals of the British legal order, a shift in what we sometimes refer to as the rule of recognition, that analysis was specifically disavowed by the majority of the Supreme Court in the first of the Miller cases. So if we put aside these two rather extreme views, neither of which I think provides a viable account of what has happened, then what does that leave us with? Well, in answering that question, I think a good starting point is the judgment of Lord Justice Laws in the case of Thoburn and Sunderland City Council. I won't go into the facts of that case in detail. Rather, I just want to remind you that the central proposition established in that case, or rather set out in that case in what are strictly obiter comments, is a distinction between two different kinds of legislation. That sort of distinction is anathema to an orthodox view of the British Constitution. On that view, all legislation enacted by Parliament is equal, and among other things, that means that all legislation can be repealed, either explicitly or impliedly. This is one of the reasons that accounts for the way in which we sometimes characterise the Constitution as flat, in the sense that there is no, on this view, no hierarchy of legislation, and therefore no body, for example, of constitutional legislation that has a different status, reflecting its constitutional character. But Thoburn rejects that orthodox analysis. According to Lord Justice Laws in Thoburn, all legislation is not equal. Some is immune from implied repeal, and the legislation that's immune from implied repeal is constitutional legislation, legislation that relates to the interaction of the arms of the state, or that governs the relationship between the citizen and the state. If legislation is constitutional on that definition, then, says Lord Justice Laws in Thoburn, we regard it as constitutional legislation, and the significance of that is that it cannot be impliedly repealed. It can still be repealed, but only through specific or express language. So it has a modest degree of protection against implied repeal, and in that sense it is marked out as having a different and rather higher status. And so in this analysis, we see the emergence of a more hierarchical conception of how the Constitution is structured. If we think about how the analysis in Thoburn might help us to understand factor time, in other words, if we try to think about what would happen if we tried to take the thinking in Thoburn and apply it to the facts of factor time, then we can perhaps see more clearly what it was that Lord Justice Laws had in mind. On a traditional analysis, we would always expect a more recent statute to prevail over an earlier statute. Now, in one sense at least, the factor time case was about the relative priority of the Merchant Shipping Act 1988 and the European Communities Act 1972. The 1972 EC Act contains what we might call the primacy instruction. In section 2 of the Act, we found an instruction to British courts to give effect to domestic law subject to directly effective EU law. This can be interpreted as an instruction to accord primacy to directly effective European Union law. But if we apply a traditional analysis, were we to find, as we arguably did in the 1988 Merchant Shipping Act, an intention on the part of Parliament to legislate inconsistently with directly effective EU law, we might expect that to override the primacy instruction or to switch off the primacy instruction in the earlier EC Act. And on that basis, we would expect domestic law, in the form of the Merchant Shipping Act, to have prevailed over directly effective EU law, because the later Domestic Act would have switched off or limited the primacy instruction in the earlier EC Act. Thoburn, however, suggests a different way of thinking about this. According to Thoburn, a constitutional statute will prevail over an ordinary statute unless the ordinary statute explicitly or otherwise specifically derogates from or repeals it. Now, in Thactotame, we had, if you like, a competition between a constitutional statute in the form of the the EC Act and an ordinary statute in the form of the Merchant Shipping Act. The primacy instruction, as we've seen, is contained in the EC Act, which now, applying Thoburn, is to be regarded as a constitutional statute. Was the primacy instruction switched off by the Merchant Shipping Act? On Thoburn analysis, no, it wasn't. The Merchant Shipping Act, being a merely ordinary statute, will give way to the EC Act unless the Merchant Shipping Act uses explicit or specific language to contradict the EC Act. It didn't do that. And because it didn't do that, the primacy instruction in the ECA was not switched off. It remained operative. It continued, therefore, to confer priority on EU law, and therefore directly effective EU law took precedence over the non-constitutional, the ordinary Merchant Shipping Act. So European Union law prevailed. This shows us how Thoburn managed to ascribe a form of pragmatic primacy to EU law. The question is, did it do so by reconciling the primacy of EU law with the doctrine of parliamentary sovereignty, or did it in effect allow the doctrine of the primacy of EU law to cast the sovereignty of Parliament to one side? Well, on that wider question, these comments of Lord Justice Laws in Thoburn are significant. He said that the conditions of Parliament's legislative supremacy in the UK necessarily remain in the UK's hands. In saying that, he was rejecting an argument that had been put to him to the effect that European law had somehow entrenched itself and had somehow managed to give itself overriding force in the UK. Lord Justice Laws rejected that view and argued that to whatever extent European law had force or even overriding force in the UK, it acquired that status and it retained that status because domestic law gave it such a status. Having dealt with that argument, Lord Justice Laws went on to say that although the conditions remained in the UK's hands, the traditional doctrine of parliamentary sovereignty had been modified. Not done away with, but modified. And he said, it has been done by the common law wholly consistently with constitutional principle. Because, he said, the scope and nature of parliamentary sovereignty are ultimately confided to the courts. That may seem to suggest that Lord Justice Laws is aligning himself with the kind of position that we know Sir William Wade staked out, where he said that sovereignty lies in the keeping of the courts. But in fact, Lord Justice Laws is advancing quite a different view. and also quite a radical view about the relationship between the common law constitution and Parliament's authority to make the law. On a traditional view, Parliament sits at the very apex of the British Constitution's arrangements. Its authority to make law is something that we can't really go behind. It is there at the top of the system, and it isn't to be questioned. It follows from that traditional view that other forms of law, including the common law, are subject to Parliament, and that the common law applies only to the extent that it is consistent with what Parliament has legislated. This traditional view aligns closely with the highly flexible view of the Constitution that we've been considering and testing throughout these lectures. Because on this view, the Constitution's flexibility or malleability is guaranteed by the sovereign authority of Parliament. The ability of Parliament, on this view, to drive through any legal change, including any constitutional change that it wishes, safe in the knowledge that nothing else can get in the way, and that there aren't any other fixed aspects of the Constitution that limits Parliament's authority. But the view advanced in Thoburn, in the course of providing an explanation as to how this idea of constitutional statutes might come about, the explanation advanced in Thoburn is quite different. Indeed, to an extent, it reverses our traditional understanding. Now, on this view, the common law constitution, says Lord Justice Laws, sits at the apex of our constitutional system, and Parliament's authority to make law is a function of that common law constitution. It follows that the common law constitution may operate to limit Parliament's lawmaking authority. In terms of where Thoburn gets us to on this matter, the common law constitution appears to impose only very limited restrictions on Parliament's authority to make the law. The only restriction that Thoburn identifies is the requirement that if Parliament wishes to repeal or derogate from a constitutional statute, then it must use express words or specific words. But the crucial conceptual point about Lord Justice Laws' analysis in Thoburn is that the reason why, in the first place, a constitutional statute is a constitutional statute is not because Parliament made it such, but rather because the common law constitution acknowledges it to have that status. And that suggests that ultimately it is the common law constitution that delimits the authority of Parliament, not the authority of Parliament that limits the common law. Now, it's important to recognise that Lord Justice Laws' judgment in Thoburn is only the judgment of a lower court. That said, it has been discussed significantly in other cases, and it has been given a degree of endorsement in other cases, including at Supreme Court level, in judgments like Miller 1 and in HS2, to which I'll turn in a second. But given that it is only the judgment of one judge in a lower court, we shouldn't necessarily assume that the Thoburn view is the definitive view of these matters. It does, however, offer a very significant and interesting take on the Constitution, and it demonstrates the way in which the interaction between the British Constitution and the European Union legal system has drawn out some really quite fundamental issues about how the British Constitution itself works. Let me turn then to the HS2 case. This was about the process adopted for granting planning consents for the High Speed 2 HS2 rail project. Now, EU law in relation to matters of this nature requires a participative process, one that affords an adequate degree of participation to members of the public. The government had decided that in relation to this project, partly because it was so far-reaching and wide-ranging, that the process of granting planning consent would be undertaken through the enactment of primary legislation rather than through the normal planning system. The question then arose whether or not that parliamentary process was adequate given the EU requirement of participation. And that then raised a further question, which was, could a court consider the adequacy of that parliamentary process, given that Article 9 of the Bill of Rights prevents courts from adjudicating on certain proceedings within Parliament? What this boiled down to was a question as to whether or not EU law could require the courts to cast aside something as fundamental as Article 9 of the Bill of Rights on the basis that EU law has primacy. Now, in the end, the Supreme Court decided that EU law didn't in fact require any kind of scrutiny of parliamentary process that would fall foul of Article 9 of the Bill of Rights. And it was also decided that the degree of parliamentary process that was being undertaken was adequate given the demands of EU law. But that left the question hanging in the air. What if Article 9 inconsistent scrutiny had been required? Would the Supreme Court have had to say that EU law trumped Article 9 of the Bill of Rights, even though the Bill of Rights is regarded as a constitutional statute? So the issue that we have in HS2 is quite different in one important sense from Thoburn. In Thoburn, we had a tension between an ordinary statute and a constitutional statute. In HS2, we arguably have a tension between two pieces of constitutional legislation, the EC Act and the Bill of Rights. Here's what Lords Neuberger and Mance said in their joint judgment in HS2. And you might want to note that there are some points of similarity and some points of difference here between what Lord Neuberger says and what he said in the lecture that I referred to in my first lecture in this series. They said that the UK has no written constitution, but has a number of constitutional instruments. And they include Magna Carta, the Petition of Right, the Bill of Rights, and the Claim of Rights Act, the Act of Settlement, the Act of Union, and now more recently, the European Communities Act, the Human Rights Act, and the Constitutional Reform Act. The common law itself also, they said, recognises certain principles as fundamental to the rule of law. It is, they said, putting the point at its lowest, certainly arguable, and it's for the courts to determine, that there may be fundamental principles, whether contained in other constitutional instruments or recognised at common law, of which Parliament, when it passed the EC Act, did not either contemplate or authorise the abrogation. What they seem to be saying here, then, is that when Parliament enacted the EC Act, notwithstanding that the EC Act is itself recognised as a constitutional statute, it doesn't necessarily follow that the EC Act was invested with the kind of legal weight or authority that would cause it, and therefore the EU law to which it gave effect, to prevail over any and every piece of other constitutional legislation and over any and every fundamental constitutional principle. So as I said, Thoburn presented us with a more straightforward picture because we had a question about the relationship between what was regarded to be a constitutional statute in the form of the EC Act and an ordinary statute in the shape of the Merchant Shipping Act. In contrast, HS2 presents us with a constitutional statute in the form of the EC Act that gives effect to EU law, And then Article 9 of the Bill of Rights, which it was argued, albeit in the end unsuccessfully, was inconsistent with one of the requirements of EU law to which the EC Act gave effect. So HS2 shows us that these more complex questions can arise. And it also shows that there are two additional nuances which arise when these sorts of questions do come up. First, they suggest the possibility of relative weighting within the category of things that are regarded as constitutional. To put it bluntly, what Lords Neuberger and Mann seemed to be hinting at was the idea or the possibility that while the EC Act might be constitutional in nature, some other things might be more constitutional or super-constitutional in nature, such that the merely constitutional may not prevail over the more fundamental still. So first then, we have this possibility of relative weighting within the constitutional category. And then secondly, HS2 reminds us that this debate about constitutional legislation is one that sits within a wider picture, and it's a wider picture that also involves not just constitutional legislation, but constitutional principles. Lords Neuberger and Menz were careful to characterise Article 9 of the Bill of Rights not merely as a constitutional instrument, but rather as a provision that reflected a pre-existing constitutional value that reflects and is rooted in the separation of powers and in our understanding about the extent to which courts should and should not involve themselves in matters that go on within Parliament. So in this second sense, HS2 underlines that the notion of constitutional statutes developed in Thoburn and given a degree of support in HS2 itself doesn't sit in isolation, but is part of this wider picture that we've already looked at, whereby there is a set of fundamental constitutional principles that also need to be taken into account. Let me try to draw some conclusions then. What can we learn from these cases that have attempted to grapple with questions about the accommodation of the primacy of EU law during the period of membership of the UK in the EU? Well, first, what does it tell us about parliamentary sovereignty? It suggests that sovereignty could be, and to an extent was, reimagined in order to be able to accommodate the primacy of EU law. It is through, or one of the ways in which that has been done, is through the articulation of this novel distinction between constitutional and ordinary statutes that a degree of pragmatic primacy could be accorded to EU law. We also see, as I've just mentioned, that we have a hierarchical layering within the category of legislation enacted by Parliament, so that the flexibility that has been injected into the doctrine of parliamentary sovereignty extends as far as this hierarchical layering, which the HS2 case suggests is not simply a binary matter, a matter that involves distinguishing between constitutional and ordinary statutes, but is a more subtle matter of degree that turns on the relative weight of competing constitutional provisions and constitutional principles. There are broader implications too. HS2 reminds us that this notion of hierarchy within the realm of legislation isn't hermetically sealed from the wider constitution, and that gives rise to this complex interplay that's hinted at in HS2 between ordinary legislation, constitutional legislation, and wider constitutional principles. We also see in Thoburn that on that view at least, it is the common law constitution itself that generates the constitutional status accorded to constitutional legislation. So we see here a complicated picture, one that moves away from a very simplistic view of a rigid doctrine of parliamentary sovereignty, and sovereignty is a steamroller that overrides everything in its path, and that locates the notion of parliamentary sovereignty in a richer and more complex constitutional picture. And that links directly back to this question that we've been considering throughout these lectures about the flexibility or otherwise of the UK Constitution. On the one hand, the UK's EU experience suggests that the sovereignty of Parliament is more flexible than we had previously supposed. It was capable of accommodating the primacy of EU law without being treated in the rather brittle way that would have required us to treat sovereignty as having been extinguished or overridden by EU law. It was reconceived in a way that could accommodate EU primacy. But whereas on the one hand, sovereignty is reconceived in these more flexible terms, other aspects of the Constitution arguably have been revealed as a result of EU membership to exist as more fixed points within the constitutional order. Cases like Thoburn and HS2 place the common law constitution in the spotlight, and they emphasise that alongside the sovereignty of Parliament, we have to take into account those other aspects of the constitutional order that exist as fundamental common law values and principles. And they serve to remind us that the true nature of the Constitution only emerges once we understand the way in which the legislated parts of the Constitution interact with the unlegislated or common law aspects of the Constitution. Now, is any of this relevant now that the UK has left the EU? Well, of course, some of these immediate issues have fallen away. But for two reasons, I think that these insights that EU membership affords us do remain pertinent. The first of the reasons for that is a pragmatic one, which is that although the EC Act has been repealed, the withdrawal agreement is still given primacy and direct effect by domestic law. And so we still need to accommodate these notions, albeit in a more limited context now. But secondly, and more generally, there are much broader implications that we can take out of the experience the UK has had while it has been a member of the EU. Membership of the EU involved seemingly putting a rigid doctrine of the sovereignty of Parliament up against an equally rigid doctrine of the primacy of EU law. And as we observe the way in which those two phenomena have interacted during the period of membership, much has come into focus about how the UK Constitution works. In particular, as we've seen, the sovereignty of Parliament has been revealed to have a degree of malleability that it may not previously have been thought to have. And in the course of revealing that malleability, aspects of the common law constitution have been revealed, which lend the constitution a more durable character in some regards than it might traditionally have been assumed to have.